Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn the subscription. And we're doing very well in subscriptions, as you can see, and I appreciate every one of you who has subscribed recently. For today's story, we're discussing an error that was made by the judge in the issuance of the jury instructions. So there is a mistake. How big a mistake it will be and who will notice, I don't know. But of course, then when there's any kind of mistake of any kind, you always have to worry about potential issues on appeal. So it's a weird possibility that could emerge, and I'm just going to show you what the issues are and show you what it is. So yeah, not clickbait. It is a real issue. How big an issue it is, of course, we can't say. So first, we're going to listen to the judge, okay? So we're going to listen to, this is at the end of the closing arguments. So Ron Bourne has just got done doing his 5.5-minute super close. And the judge is about to issue instructions to the jury. And so what I want you to do is I want you to listen to these instructions. I want to see if you can spot the error. Now, I've already discussed this on other channels. So if you know the answer, don't spoil it for others. Okay? We're going to listen to this again, and we're going to see if you can spot the error that I spotted when I listened to this when it was happening. So, all right, let's listen to this, and we'll go from there.
Members of the jury, this is an important case to both the plaintiff and the defendant. In order to reach a verdict, each of you must agree on that verdict. In other words, your verdict must be unanimous. The first thing you should do when you go back to the jury room is to select a presiding juror. The role of the presiding juror is to see to it that the deliberations are conducted in an orderly and businesslike manner, that they are conducted only in the jury room when all the members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. It is rarely helpful for jurors upon first entering the jury room to take a straw vote, or for any juror to make an emphatic expression of his or her opinion in the case, or to announce a determination to stand for a certain verdict. To do so before all jurors have had an opportunity to consult with one another and exchange views and opinions might allow your sense of pride to prevent you from retreating from an announced position, even when shown that such position is unsound. You have a duty to consult with one another and to deliberate with the objective of reaching an agreement, if it can be done without offending your individual judgment. Each of you must decide this case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of deliberation, a juror should not hesitate to re-examine his or her views and change his or her opinion if convinced it is an error. However, none of you should surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. In the jury room, you will have the exhibits that were entered into evidence. You will also have the instructions of law that I just read to you, and you will have the verdict forms. You'll also have a laptop, and that laptop will have just 2 files on it, and Deputy Lusa will set it up for you in the jury room. One is the plaintiff's files for audio and video files, and one's the defendant's files for audio and video files, and you'll be able to hear and watch those as well, the ones that were submitted into evidence. During your deliberations until you are discharged from jury service, you must not communicate with or provide any information to anyone who is not a member of this jury by any means about this case. You may not use any electronic device or media to conduct any independent research about this case, the legal or factual issues in the case, and the individuals or attorneys involved in the case. You are not permitted to consult dictionaries or reference materials, search the internet, visit websites or blogs, or use any other tools to obtain information about this case or to help you decide the case. Do not try to find out information from any source outside of the testimony and the exhibits received as evidence during the trial. You will also have, I know the attorneys discussed briefly about the verdict forms. You'll have 2 sets of verdict forms, one for Mr. Depp's case and one for Ms. Heard's case, okay? Now, when you have these verdict forms, the first 3 pages of both verdict forms have each of the statements separately. Okay, so when you're going through it, you're going to look at each statement separately and answer the questions that are on the page, okay? Now, if you decide yes for every question for a statement, then that's when you go to the last page of the verdict form, which is for damages. So, for example, if you find yes for all of statement 1, then you could go to 4 and 5 for damages. If you find yes for all of statement 1 and statement 2, you still go to 4 and 5 for damages. If you say yes for statement 1, statement 2, and statement 3, you obviously go to 4 and 5 for damages. If you answer no on any of the pages for any of the statements, you don't go to 4 and 5, okay? So that will be for all of them. And then when you do come to a verdict, make sure the foreperson signs it and dates it, and then just let the deputy know about that, okay? All right, now, for the tough part.
Okay. So you can actually spot the error without seeing the jury forms. So if you spotted the error, you get a cookie. You get a cookie. The judge made a mistake. The judge made a mistake in the way she recited it. So we'll go back to where it was. It was right at the end. And listen to what she says again. Right here at the end, okay? It's about the yes and no part, okay? Listen to what she says.
You're going to look at each statement separately and answer the questions that are on the page, okay? Now, if you decide yes for every question for a statement, then that's when you go to the last page of the verdict form, which is for damages. So, for example, if you find yes for all of statement 1, then you could go to 4 and 5 for damages. If you find yes for all of statement 1 and statement 2, you still go to 4 and 5 for damages. If you say yes for statement 1, statement 2, and statement 3, you obviously go to 4 and 5 for damages. If you answer no on any of the pages for any of the statements, you don't go to 4 and 5. Okay, so that will be.
So there are two mistakes she makes here. There are two mistakes she makes. One is where she says if you answer no on any of 1, 2, or 3, which is incorrect because they only need one of them. So what she meant to say was all, not any. That was the mistake. She said any instead of all. So what she meant to say was if you find no on 1, 2, if you find no on any, or you find no on all of 1, 2, and 3, you don't go to 4 and 5. Right? Instead of if you find no on any of 1, 2, and 3, you don't go to 4 and 5. So that was the slip of the tongue. Any versus all. And goes to show you how words matter. There's also one other error in the instructions where she said, if you find it on 1, right, you go to 4 and 5. If you find it on 1 and 2, you go to 4 and 5. If you find it 1, 2, and 3, you go to 4 and 5. What's the mistake? What's the mistake? The mistake is in every possible case, you have to say yes to 1. Right? That's what she said. She said, if you find yes on 1, go to 4 and 5. If you find yes on 1 and 2, go to 4 and 5. If you find yes on 1, 2, and 3, go to 4 and 5. So what's the problem? It requires you to find yes on 1. And incidentally, if you get to 1, so yeah, if you don't get to 1, strictly speaking, by the way she worded it, by the strict letter of the strict word she used, you would never proceed to 4 and 5. So if you didn't find 1, the way she worded it, you wouldn't proceed. And we'll listen to it one more time because it just goes to show you why you have to be really precise in these languages.
You're going to look at each statement separately and answer the questions that are on the page, okay? Now, if you decide yes for every question for a statement, then that's when you go to the last page of the verdict form, which is for damages. So, for example, if you find yes for all of statement 1, then you could go to 4 and 5 for damages. If you find yes for all of statement 1 and statement 2, you still go to 4 and 5 for damages. If you say yes for statement 1, statement 2, and statement 3, you obviously go to 4 and 5 for damages. If you answer no on any of the pages for any of the statements, you don't go to 4 and 5, okay? So that will be for all of them.
So yeah, she made a mistake. She made 2 mistakes. Because strictly speaking, you only need one of them. So she should have said or. She should have said or. So if you said, hey, if you find it on 1, great, go to 4 and 5. If you say if you find it on 1 or 2, you could go to 5. If you find it on 1, 2, or 3, not and. So and versus or and any versus all are your errors of the day. Now, This is now how big a problem is this? Well, it's a minor problem because the instructions themselves also are really, really confusing. So let's go to the actual written instructions, which I don't really know help that much. So let me find the right thing. That one, this one. Okay, great. Let's go to the actual written instructions, which also are not great on this point. So here's a copy of the written instructions. So for example, here's number 3. It doesn't really matter because, it's just one of them. There are 3 statements at issue: the title, the one about the domestic assault, and the one about this, the rare vantage point of seeing in real time how institutions protect men accused of abuse. So there are 3 separate statements they're meant to evaluate. All right. And then here's what it says on the next page, the damages section. This has got to be worded better. There's got to be a better way of wording this, because this is a kind of wording that can only make a logician happy. Complete questions 4 and 5 only if you answered yes to all of questions 1, 2, or 3. Now, tell me that's not confusing. Tell me that's not confusing. Complete questions 4 through 5 only if you answered yes to all of questions 1, 2, or 3. Now, here's the problem. It is correct the way it's written. But if you see answer yes to all of questions 1, 2, 3, you are depending on the jury knowing the difference between and or. And I have to tell you, having covered enough court cases in my time, sometimes the courts aren't so clear on the and versus or thing. Sometimes they're not so clear on the and versus or thing. I've heard attorneys argue at the Supreme Court that and means or, and or means and. So the way it's written, technically speaking, is correct, but first of all, it's confusing as hell. Second of all, if it wasn't confusing as hell, which it is, in light of what the judge said orally in the view of the instructions, it's even more confusing. Because the judge said, well, okay, if you find one, then if you find 1 and 2, if you find 1, 2, and 3, now suddenly we're talking about 1, 2, or 3, and we said about any of them, we said about all of them, but what we really meant any of them, and now we're back to all of them again, and so the whole thing is just a confusing nightmare of confusion. So, what does this mean? Well, so there's a mistake. There's a mistake in the law. And so, yes, so the issue is the best case scenario for the Johnny Depp's people is if they come back with all of them, 1, 2, and 3. That's the best possible scenario because it probably renders any issue moot. So if they say yes to 1, 2, and 3, then they should be covered, right? Because then they follow the judge's instructions both on this and that, right? Because they said yes to all. That's what the written thing says. And then they also said yes to 1 and 2 and 3. And that was also in the jury's in the system. So there is a way for them to come out with a verdict that's fully consistent with both sets of instructions at the same time. It's just that there are ways for them to reach verdicts that don't appear to be consistent with it. So if they say yes to 1, 2, and 3, great. If they say no to 1, that's a problem, although 1 is their best case. So it would be a bit odd if the jury said no to 1 and yes to the other 2, because 1 is the best case for Johnny Depp, in my opinion. I mean, personally, as hypothetical juror, I'd be inclined to vote no on number 3. I think one is yes. Number 2, I lean strongly yes. And number 3, I think is a no. Although I, as hypothetical juror, am not going to fight you about it. So if it comes down to the end of us in the jury room and there are 6 votes for yes for number 3, and it's me versus the rest of the jury, I'm not dying on this hill. We can all vote yes and move on with our lives. It's fine. It's not that big a deal. It's just, personally, I don't think 3 has been proven, but that's me. Anywho, so it only becomes a problem if they vote no on some of these. And it becomes a real problem. It becomes a real problem if they misunderstand the instructions and they come back with this page blank, having answered yes to 1, 2, or 3. Okay, because the jury could get confused. Now, of course, the jury can ask for clarification. That's a thing they can do. So maybe they ask for clarification. But here's the hypothetical I'm worried about. I'm worried about the hypothetical that they don't say yes to all of 1, 2, and 3. So they don't come yes across the board. And I'm worried they misunderstand some combination of the judge's oral instructions and or the written instructions, and they come back and this page is left blank, which puts the court in a really, really awkward position. Because now you have a jury verdict form that says, yes, we found it as to at least one of them, and they left out the amounts. They left the amounts blank. So, like, what do you do as a judge here? I don't know. I guess you have to send them back. You have to basically give them the instruction again, and just give them the instruction again and send them back for further deliberations, but you can't make clear what the deliberations are about. See, this is a problem for the judge. So if they come back with 1, 2, or 3, but they don't complete this page, you probably can't say, okay, I need you to go back and deliberate on damages because you found liability. You don't want to do that. So you probably need to give it more obliquely. It says, like, so you repeat the instructions dealing with the issues of 1, 2, 3, and what they need to find. And so basically all you need to do at that point, I think, is say, okay, the jury forms are inconsistent, but then there's no way to do this without teeing everyone off that one of them is yes. That's the problem I have as a judge. Like, there's no way to do this for me to give instructions to the jury that doesn't tell everyone in the room that the jury has found at least one of them. Because otherwise, nothing I'm saying makes any sense. So it's like, I could say, well, here are my instructions as it regards to 1, 2, and 3. And anyone with a brain in their head, well, mostly me, but no, that's unfair. I was just trying to make a joke. But, anyone who has a brain in their head sees, oh, wait a second, I have a problem. And, I don't know how you fix that problem. So the best case scenario is they come back with all of 1, 2, and 3, and this page formed out, or they do some combination of 1, 2, and 3 with some difference. If they say no to all of them, then I guess, and they still come back with damages, that would be really weird. But if they come back with some combination between 1, 2, and 3, but they still get to damages, then I guess we ignore the whole thing. But I wanted to bring this point to your attention because there is a problem here, and when you're thinking about the possibility of appeal, you're looking for any kind of legal error you can find. And it's like, well, I found one. I found a legal error. So, it may or may not matter in the end. But if I'm thinking about possible roads of appeal, it's like, well, I got one on some possible thread of analysis, because the question will be like, if I send them back for further discussion on damages, improper influence by the judge, and blah, blah, blah. And, it's just like, yeah. Out 2 and 3 without 1, yes. I mean, some combination of this. So, like, the whole thing is a little bit messy. Yeah. And then, like, there's other possibilities, too. John Campbell points out, what if they answer no to 1 and skip 2 and 3 because of the instruction? That's also a possibility. Good spot, John. That's also a possibility of a way of interpreting your instructions, though the terms are ambiguous. So it says, can the judge call them in the first thing on Tuesday and amend? Yes, they could. Yes, they can. They can bring them all back and be like, okay, I made a mistake in the instructions, so I'm going to reread the instructions. Now, what you do here, if you're the judge and you catch the error, what you do here is you just reread all the instructions, because you can't spot that. You can't make a big deal out of the particular error because you don't want to unduly influence them. So the only way to do this really is to bring them all back in, reread the jury instructions, reissue the jury instructions, and every member of the jury wonders what the hell was the difference, because it will sound all the same to them. But, that would cure the error. So if the judge spots the error, if the legal team spots the error, and they're like, hey, judge, when you said this, you said it a bit ambiguously, so we'd like to have further instruction on this. It's like, yeah, we can just redo jury instructions. Why not? That'd be good. So You're overthinking this in a major way, dude. DT. Oh, DT. I'm really not overthinking this. This is the kind of thing that lawyers look for as part of legal errors. I'm not really overthinking this. When lawyers are thinking about legal issues and they're thinking about legal problems, I mean, issues have gone to the U.S. Supreme Court over arguably less than this. I mean, this issue won't go to the U.S. Supreme Court because there's no federal issues here, but, still. I mean, these kinds of ambiguities, these kinds of problems, and these kinds of issues, when you're like, oh, wait a second, there's a flaw here. This is the stuff that courts of appeal are built for, man. I'm not overthinking this. This is what the courts of appeal were dealt with the dream of. So, yeah, I mean, this is just, I'm like, oh, I spotted a problem. Oh, yeah. Yeah, that's this is what the lawyers get paid for. The lawyers get paid for overthinking the hell out of everything because, we want to serve the client, and if we overthink the hell out of everything, maybe we can spot a path forward for you, So overthinking things is kind of a trait on the profession. Debbie Lowe says, will we get a smile from you when you reach 100K? Hey, you don't have to wait. Pollyanna said, give me some cookie, Kurt. And she said, file instead of files. If you're the judge, how would you judge? To love Camille? Yeah, Camille kicks ass. And I like this judge very much. I disagree with her interpretations about some of the things, but she's being consistent. So, for example, the foundation issues aren't as much a problem for me as they are for her. And I think her definition of hearsay is a little overly broad, but she's consistent. So, it wouldn't be enough for me as a Court of Appeal judge to reverse. See, if I'm the judge, if I'm the trial judge, I would issue different orders. But if I'm the Court of Appeals judge reviewing her decisions for those aspects, I'm like, I can't say they're clear error. I think she's wrong. I think I would do something different, but I can't fix the problem on the Court of Appeals level because I need more than just a mistake. I need clear error, and I don't think it's that. It's just a disagreement. It's a disagreements of opinion. $2 from Miss Jane Bronte. So how do they fix the mistake? Reissuing the jury instructions would be the best way to do it, I think. Angelica becomes a new member. Thank you for hitting that join button. MHL. The 1, 1, 2, 1, 2, 3 were 4 examples. She didn't say all the combinations, but I agree she could have been much clearer. Yes, unfortunately, all of her examples were predicated on them finding 1. They were all, in fact, examples, but all the examples were predicated on them finding 1. So, there's that. JB Afros says, for $1.99, you're right, and I'm disgusted. Starry Seller, can they ask for a point of clarification while deliberating? Sure, they can ask for a point of clarification if they notice the problem. But maybe they don't notice the problem, and maybe they don't even ask even if they notice the problem. And maybe they submit forms, because the judge is not going to see the forms until the moment they're delivered. They're going to be put in a sealed envelope. Here's what's going to happen. The judge is going to, there's going to be a note from the jury to the bailiff that says, we've reached a decision. They're going to fill out the forms and they're going to put them into a manila envelope. The judge is going to get on the phone and say, hey, y'all, we got a verdict. You might want to show up. Everyone shows up, right? The jury comes in, For the first time, they say, hey, do you have a verdict? And they're like, yes. And they say, please hand the verdict to the clerk or the bailiff or whatever. So the foreperson of the jury with the manila envelope in their hand, usually this is how it's done, hands it to the clerk or bailiff who hands it to the judge. This is the first time the judge sees what's inside the envelope. It's like, yeah, we're doing the whole Price Waterhouse thing. And the winner for Best Picture is, we open the envelope, and depending on what's in there, we run into problems. So it could lead to a very awkward moment, potentially, when we're delivering the verdict from the jury. So, there's that. Yes, I was answering super chats. I forgot what I was doing for a second. Crystal became a new member. Phil H said, 999, thank you for making this stream. It was driving me nuts. Was sad you guys didn't dive deeper into it on a Alita stream. Well, we do what we do. Forever Cucumber says, hey, Kurt, was the instruction for AEH to be purged from society? Kidding. Keep up the great work and don't ever change. I thought it was a good joke. Chris Anderson, do you have a video of your view on the Second Amendment? I believe I do. Somewhere on my channel. I've talked about it a couple times before. Wanda says for 1999, I was so confused by the instructions and thought I was stupid for not understanding all the instructions. So glad I found you on your channel. Yeah, some of the instructions just need help. Tina M gave $10. Thanks for all your insight analysis. Diana DiCarlo gave $5 to give me a ha 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 dancing pear emoji. Awesome. Eric said AH verdict 2A can result in infinite loop as well. Yep. Known terrestrial, why do you think all the attorneys in the room missed this? I'm not sure they necessarily did, but then again, it's been a long day for a lot of them, and so they might have missed it. They might not have. I don't know. Peter said, overthinking details of this words is literally a lawyer's primary job. I mean, preach, Peter, preach. Overthinking the details of words is literally a lawyer's primary job. Yeah, I'm overthinking this. No, this is just what my job looks like. And I'm a patent lawyer, man. I'm a patent lawyer. No one can overthink words like me. I guarantee you. I am the king of lawyers when it comes to overthinking about the meanings of words. Holy God. Tread gave $1.99. I appreciate your logic as much as mine. Thank you very much. Miranda Deadly says, lawyers study overthinking. We pay them to do so. Congrats on the sub count. Thank you very, very much. If one is Boogie said, if one is SA or republishing, I'm not as worried. Yeah, I think one is their best bet. One is the first statement about the sexual violence. That's the title headline is one. And I think it's their best case among the three. So, like, it probably won't be a problem if they're inclined to fine for Johnny Depp, because it would be a little bit weird for them to fine not for the first one and fine for like 2, or fine not for the first 2 and fine for 3, which incidentally, if they fined only for 3, which is a very weird possibility, but if they find only for 3, I think Amber Heard's odds on appeal go up dramatically. So there's some weird combinations out there. Fuel Me Once says, I conduct readability and other linguistic analysis of legal docs. This is exactly how attorneys argue. Preach it. Michael says, do you know if they can change the instructions if an error is identified? Yes, they could reissue them because the jury's not done deliberating. So you can bring the jury back in and be like, okay, we made a mistake and I need to reissue instructions. And you just do them all over again and they don't know the difference, but at least you've clarified the error for the purposes of appeal. Amy says, maybe I'm dumb, but to me, it sounded like she read, if you do not say yes to all page 1, 2, or 4, it needs to be reread. Yeah, I mean, well, yeah. Gus said, hearing tortoises makes me hungry, and sharing your voice becomes a new member. Well, thank you very much. And thank you to the 94,337 of you, 40 of you who are currently subscribers on this channel. It is really, really appreciated. The jury will be back on Tuesday. I hope everyone does have a good Memorial Day. Try to get out there, have some sun, have a burger, have a hot dog, fly an American flag, set up some fireworks, listen to the Battle Hymn of the Republic at 11 on your home stereo, all that good shit, and all that good things. So yeah. So do all those things, and also remember to do all the YouTubey things. So if, first of all, and of course remember the fallen, I'm of the opinion, and I don't know if it's just me, but I'm of the opinion the best way to remember the fallen is by living the best lives we can. They have fought for our freedoms, and they fought for us to be able to go to barbecues and hot dogs and hamburgers and parades and flags and all the rest of it. So I think personally it's very honoring to spend time with friends and family and go to the pool or go to the pond or whatever it is and enjoy the freedom that we have earned through our own blood. So I think that's a very patriotic thing to do, but if you celebrate Memorial Day otherwise, then that's also fine by me. If the subscribe button is red, please click it. So many of you have clicked the button. In fact, 94,364 of you have clicked the button. I'm now really liking this counter on screen. I should have done this a long time ago. It's badass. And it's a lot cheaper than the thing Alita has on her table. Plus, it's automatic in real time, where hers lags a little bit. So that's cool. And yeah, and also hit the like button and all the YouTubey things. As always, I hope you'll be fine. I will talk to you again soon. I've been Uncivil Law. Until later, my friends, peace and good night.